supplementary cost list, item number 1.
Lordship, this is an application for condonation of delay, Lordship. We have preferred an appeal, Lordship, against the judgment and order dated passed by the court at Nagpur, Lordship, whereby I have been convicted under section 302 for life imprisonment.
302?
Yeah, Lordship. 49 days. 49 days delay, Lordship.
Heard Mr. Legal Counsel for the applicant, who has submitted that this application has been filed with a prayer for condonation of a delay of 49 days in filing the related appeal. On consideration of the good grounds shown, petition is allowed, delay is condoned, petition disposed of. The registry directed to diarize the main appeal. Diarize the appeal and list it accordingly, and list the same accordingly. The main appeal. On this appeal being admitted, the lower court records are hereby called for. The appellant is directed to prepare the paper book. The same to be done so within 6 weeks from today. This is matter accordingly.
On daily cost list, item number 1.
Oh, I have to Mr. Okay, appears for the respondent. Still respond. No notice is required.
Please, Lordship. As for the order dated 07/11/2022, Your Lordship, where the appellant was directed to amend the co-stator instead of Donji, that have been already done, Lordship. I've corrected. However, Lordship, I pray some accommodation to argue this matter, Your Lordship, because the correction is that only maybe after some time, maybe.
May I please, Your Lordship? May the power be filed on behalf of the newly impleaded appellant.
Newly impleaded one?
No, not appellant. I am the appellant.
Appellant?
Appellant
Yes,
number 3.
Yes. So where's the power? He is appealing for.
I am the appellant. It's not required for them to file because I am the.
May let them file the power for appellant number 3.
Yes, they will do that. Do it in this way.
Lordship, they are asking to file another Bakarna. That is
Naturally, if new party comes,
Lordship.
party will have to authorize you.
Lordship.
You have to.
That I will file it, Lordship.
That is why we have taken it
Lordship.
for granted that you have done it.
Lordship.
If it is found or recorded, it is not done so, then you have to do it.
Lordship. That today, during the course of the day, I will file it.
On prayer made by the appellant, seeking accommodation in this matter, same is allowed. This matter is accordingly adjourned. List the same after vacation.
Lordship.
Item number 2.
My Lord, I'll make with Lordship permission, make supplementary submission along with the submission of the earlier writ petition Lordship made query last time. Copy of the prayer made in the first writ petition. May I submit? My Lord, my prayer, well, page number 22. Before I take to impugn letters, page number 22. May I read out, my Lord? In the premises of our city, this therefore humbly pray that your Lordship may be pleased to consider the above. Call for records, issue rules, calling upon respondents to show cause as to why writ of mandamus shall not be issued, declaring the inaction on the part of the respondent in not issuing communication appointing the writ petitioner as agent for operating
You're
check
pointing to
station.
page 22 of which?
22 of the writ petition I submitted.
Oh,
Page 22. Page 22, Lordship. I flag it. For the first flag. Page 22.
your flag is at page 24.
My Lord, if
Anyway,
the writ petition I submitted.
yes, it's here.
The writ petition, running page number 22.
Yes.
My Lord. Inaction on the part of the respondent in not issuing the communication appointing the writ petitioner as agent for operating check station at Mukuntur and executing the formal agreement in this regard in persons to retender notice dated such. Extract copy of decision passed by the executive committee held on 8/2/2022 and authenticated by the chief executive member, Gender Years Autonomous District Council, Jawai, and letter such 9/2/2022. This is the appointment of Mr. Kindia issued by the responding. Number 4, appointing private respondent number 7 as agent to operate check station at Mukuntur as illegal and arbitrary, and or issue a writ of certiorari setting aside and quashing the extract copy of decision passed by the EC held on such, authenticated by the CEM such, and letter dated 9/2/2022 issued by the respondent number 4 appointing private respondent number 7 as agent to operate the check station in Mukuntur is illegal, null and void. And thereafter, my Lord, this is a relief advisor, direct the respondents to issue necessary communication appointing the writ petitioner as agent to operate check station in Mukuntur and to execute a formal agreement in this regard as per the terms and conditions containing the retender notice. So this is the prayer we made, my Lord. Once, my Lord, twofold prayer, may I say. I was seeking for setting aside two orders. One is the executive committee decision 8/2, and number 2 is appointment of Mr. Kindia. That was the two order I sought for setting aside. Out of 2, appointment of Mr. Kindia was set aside, but the executive committee decision was not touched. I'll come, my Lord. And the executive committee resolution, the second flag, even page number 37. Before Mr. Kindia was appointed, this was the decision after the tender committee cleared all the papers of all the parties. Page number 37 of the petition.
Annex 2. Annex 11 or Annex 2? To the licensing officer.
Office of the executive committee. Page number 37. Executive committee decision number such 08. Is it there?
It's not here.
Lordship, got it.
37 is given, something different.
My Lord, I'm sorry, my Lord. It would be page number 47. 47. That copy. 47, madam. 47, second flag, madam.
Yes, 47.
This is the decision, madam.
So this is where the executive committee has taken upon the role of the tender committee.
Yes. Here, this district council executive committee set over the file after tender committee made all the recommendations, and before issuing appointment to Mr. Kindia also, they set, because the issuing appointment and signing of the contract is with the executive committee, so they are sitting over there. Now, when they sit over there, they did not sit along with the records of the recommendation given by the tender committee, but they also get along with the reports collected from officers, some officers, and they resolve this.
Licensing officer. Sorry.
My lord. So if lordship permits me, earlier also I have noted down, I have read it out. But with lordship permission, my lord, for recollection, if lordship permits me, can I read, my lord?
Yes, yes.
My lord. Now, views and opinions, my lord, of legal advisor. District Council, they have their own legal advisor. Regarding the checkpoint at Mukuntur, CEM placed the agenda in the EEC. He informed all the members about the legal opinion on the legal notice regarding checkpoint at Mukuntur. Inspection report, legal notice is my legal notice earlier. Inspection report of the department concerned. He then sought the views and opinions of the members. Now, the assistant licensing officer briefed the EC that the office of the JJTC had reissued the tender number 18 October 2021 with respect to checkpoint at Mukuntur and Ablarin respectively. Thereafter, the tender committee, who has tasked to oversee the bidding process, had by letter since 20 December 21 had recommended to the EC the name of Stream Retaliant Law as the successful bidder. She also briefed that the executive committee had directed Mr. W. Lingdo, Trading Inspector, Taxation Department and Checkpoint, to inspect the land proposed to Stream Retaliant to set up a checkpoint at Mukuntur and to submit report forthwith to the EC. The inspection report, his inspector submitted his report with following as follows: that the land where Retaliant proposed to set up the checkpoint is situated in the right side of the highway from Jowai to Shillong. If the checkpoint is set up in the said land, the staff have to cross over to check the trading license of the vehicle. In either sides, madam, may I just pause? Either sides, either right or left, staff has to cross. It's the national highways, madam, near the national highways. 3. If the checkpoint is proposed to be set up, does not have sufficient space to stop a vehicle to check and trading license, and if the land is used to checkpoint, and if vehicles are in stop, it would result in traffic jam, thereby causing inconvenience at the vehicle in the highway. Now the tender committee said they have cleared everything. There is no such impediment, but he has given this report.
But this doesn't remain, isn't it? It is gone.
Madam.
This resolution of the executive committee,
Madam.
it was under challenge in the first round of
In the first round of litigation,
and that has been interfered.
in fact, this is not directly set aside, but Lordship, the appointment given to Mr. Kente on the basis of this resolution was set aside.
Indirect effect is that it has
Yes, exactly. Indirect effect is that this has also gone, because Mr. Kente is founded on this. Mr. Kente appointment. Second bidder appointment is founded on this resolution. So once, my lord, the appointment of Mr. Kente gone, it has a direct impact upon this resolution. Now this is the thing, my lord. So I just want to point out here that district council inspector set over and they adopted this resolution. The premium quoted by me is illusion. These are all things are there, but as the lordship point out, it doesn't have a material effect as of now. Now the order set aside by the learned single bench directly is third flag, my lord, page number 50. Mr. Kintia. This one. Now, may I come to, my lord, the order passed in this writ petition.
Yes.
Madam, I may not take the trouble to my lord to read the appointment letter, which is already set aside. Now, may I come to the memo of my appeal, page number, my lord, 75. Now, I challenge those, my lord, those appointments, and during the pendency of this challenge before the learned single bench, my lord, there was a fresh new writ petition filed by the district council itself. Now, on my lord, in the month of February 2022, the government has issued a direction to all the district magistrates that the check gates or checkpoints or toll gates operating in the national highways should be restricted, closed down, shut down. On the basis of that, my lord, the district magistrate Gender Hills had issued a letter to close down the check gate or toll gates run by the district council. Now, at that point of time, my lord, district council was running the check gates at Mukuntu. And now that order affects to them, therefore they filed a writ petition. And the interim order was, my lord, passed by my lord Justice Tingto. May I submit, my lord? My lord. 2 cents. Yes. 2 cents. My lord, here this order was passed on, my lord, 3/8/2022, and I may take a lordship now, para 1 and 2. My lord, order dated such and such passed by the district magistrate West Agenda Hills, Jawai, whereby all the toll gates said to have been illegally erected by the petitioner herein on national highway, state highways, and major district roads within the jurisdiction of the JHDC are directed to be closed down as challenged by the petitioner in these proceedings. It may be mentioned that the above mentioned order was pursuant to the communication dated such of dated such 22, passed by the Joint Secretary to the Government of Meghalaya District Council Affairs. Now, number 2, since the check gates are operated by the petitioner at Mukuntur, Market, Mukuntur, Amlarim, and Radhachara in the Jente Hill district, with the objective to detect, regulate, and identify illegal trading by non-tribal commercial vehicles without any license within the jurisdiction of the district council, closing down of one of the said check gates at Mukuntur by the respondent herein is deemed to have been an act done illegally, arbitrarily, and discriminatorily, which is liable to be interfered with by this court under such and such. My lord, now may I come to para 7, my lord? Same next para 7. The learned senior council has maintained that the check gate of the petitioner was not erected on the national highway, but about 15 meters from the same on the lay-by, and as such, there is no question of violation of the said Control of National Highway Land and Traffic Act 2002. And therefore, my lord, the last flag, lordship kindly come to page, the last flag, para 31. Accordingly, my lord, para 31, pending final disposal of the main petition, the prayer of the petitioner for stay of the operation of the impugned orders and such, related to letters and such is hereby stayed. Now, in this case, my lord, which is still pending, day before yesterday, it came up before the learned single bench. It will come up on date 20. Now, here, when the matter was filed by district council themselves, they took
this interim order was not vacated.
Not vacated, it is continued, still continued. My lord, just day before yesterday listed. And my learned friend made a submission that since division bench is, my lord, considering this matter, he sought for adjournment, and lordship has given time on date 20. Date 20, it will come up on 20. Now, in this matter, very matter, district council has taken a firm stand that it is the policy decision of the district council to conduct the check gates at Mukuntu. And where they operate, they were operating in the place first offered by Mr. Kindia, 15 meters away from highway. There was no traffic jams, no impasse of traffic. And district council has the power. State come up with the argument that no, district council has no power to erect a toll gates, check gates in the highway. And the law doesn't empower. District council said no, and the government said that you don't take the permission of the national highway. So it is illegal. Now the reply of the council, my friend, was that there was no objection raised by the national highway because the national highway belonged to the National Highway Authority of India. It is not owned by the state government. And absolutely correct, he was correct. Under National Highway Acts and Control Traffic Rules 2002, as well as National Highway Administration Act Rules 2004, it is very clear. Once the road is declared as a national highway, ownership is vested with the national highways. And therefore, any obstructions, constructions of, for example, petrol pumps or others, or any drainage, usages of the national highway, it requires permission from national highway. So state argued that permission was not there. Now, my friends say that since it did not touch the land of the national highway, there was no objections. Permission was not required, and it was running. Permission, the Lordship has granted the interim. That time, the tender which we are concerned with was already floated. Tender process was on. District Council was running that point of time. They obtained. After they obtaining this, they consider the case in the tender process. And they have given the appointment to Mr. Kende. So District Council out, Mr. Kende given. And why Mr. Kende was given? By Lord, the land is suitable. So also my land is also suitable. But why I was listed shortlisted number 1? Because my premium is higher than Mr. Kende. Therefore, I was given the first privilege. But I did not give, said they have handed over. I challenged this, and now learned single bench passed this order. During the operation of this, the interim order, where the government, District Council say that this is the policy decision of the KGDC, the District Council, to operate in Mukuntur, which is the exit point of the territory of the District Council, to check the illegal trading. Now,
so there is already a checkpoint, a check station at Mukundur.
Mukuntur already. Earlier it was run by private lessee. His term was over. Therefore, District Council taken over, and they were running it. And the running by the District Council, it affects the exchequer of the District Council. Therefore, they decided to float the tender.
Yes.
Float the tender, inviting a tender. Therefore, they float the tender. And when we participated, 11 participated. During the participation process, tender process, government issued these orders.
But where is he? I am still confused. If the checkpoint at Mukundur
Yes.
is in existence,
Yes.
No, madam.
It was
The same check gate was shifted to Cletirchi, madam.
No, that will come. Let me clarify.
no, just I'm still confused. Why would the tender committee then propose for the tenderer to, to identify another plot of land or area?
Now, may I clarify, my lord? As I submit, my lord, I try to make it clear, my lord. The private lessee was running in the place Mr. Kende offered. His term was over, and therefore District Council took over running it. And District Council took a policy decision that let us go for floating a tender, appoint the agent, and run by themselves. And they have selected the Mukundu. And NIT was out. And we participated. That time, my lord, District Council never run the check gates in Cletirchi. It was still in my lord Mukundur.
No, that was later.
My Mukundur, yes, later. And when District Council was running in Mukundur, and then the process was going on, state government issued that order, and therefore District Council rushed to this honorable court, obtained the stay order, and they run. Now, when they run, in the meantime, they were processing the tender process, my tender process, and executive committee is set on the meeting, in the meeting, and say that no, there was inspector reports, therefore my land is not suitable, therefore let us give to Mr. Kinde. So they have given appointment to Mr. Kinde. And now Mr. Kinde, before he was about to start, my lord, District Council took a decision to shift to Cletirchi. Now, policy decision of the District Council remained the same at Mukundur. Running by the District Council in Cletirchi is a stopgap arrangement because of the single bench allowed. During the, my first revision, single bench allowed that departmentally running the check gate by department should be continued until final decision. Therefore, they were running this one. Now, when we challenged this the EC decision and the Mr. Kende appointment, now this is the judgment. Now, if Lordship permits me, it is not that lengthy judgment. If we allow me to read these relevant paragraphs, my Lord, it will be more clear.
I think you have done earlier.
My Lord, earlier one I did not.
Paragraph 12.
My Lord, that is the second order we
That's the
made.
second order.
Second petition.
Or this is with regard to the first.
The first one. The first one. Well,
Yes.
my Lord, page number 75.
What relevancy it would have now? The first one, we cannot go into those.
But
I mean, like at least this court cannot cause any interference.
it doesn't matter. Because I want to refer this because they are saying that the High Court has given them the free hand to take a decision in view of this order, and therefore they issue of an offer letter to me, and they shifted to clarity. Therefore, for that purpose, otherwise, my Lord, I will not take the dropper. Let a single bench entertain my writ petitions and take away the basis of the ground reason of the EC decision also. And the single bench say that all the requirements I fulfill. However, there was a submission given by the district council. There is a subsequent development. They are referring to the Malad district government order restricting the jackets.
We're just clarifying some doubts. Yes, sir. Shangrisu, please call. You see, I don't know, so as to cut short the proceeding, our attention is drawn to the impugn order.
Yes.
At paragraph 11.
Yes.
Paragraph 11.
Paragraph 11.
I think the most relevant portion is that the observation of the learned single judge when he says the directions as spread in the considered view of the court. Have you got that?
My Lord, the first order, Lordship is referring to first order.
The
Order impugned.
The order impugned.
Order impugned here.
Come to page 8, paragraph 11.
Page number?
Page number 8, paragraph 11. Almost the last portion.
Page 130, para 11. Yes.
The direction as spread in the considered view of the court. Have you got that?
My Lord,
just I think somewhere.
Yes, yes, my lord, in the middle, my lord.
Yeah. So I
Direction
think
as apparent in the considered view. Lordship is referring to.
yes, that's the one.
My lord. My lord. The directions as apparent in the considered view of the court, in spite of sequence of events that reflects a flawed decision-making processes, awarding and thereafter cancelling the settlement of the petitioner without hearing her in the present circumstances, however, no longer available for consideration. Coupled with this fact,
See, that's the key word. See, no longer available for consideration.
hearing, my lord, right to be heard, my lord. The right to be, I took the plea. The right to be heard is no longer considered because subsequent development. That is what the court was saying.
Not necessarily right to be heard, but the whole process as such. What was done by the respondent,
Yes.
JCDC, was flawed. The process was flawed.
Yes.
But you cannot, deny the fact that it was done so under changed circumstances. So that is, I think, that is the reasoning of the single bench.
Well, now, therefore, what is the changed circumstances? That is irrelevant.
That would be the direction for as far as those VIP and the traffic and the. I think that would be the changed circumstances.
My lord, I will come to that one, my lord. May I just complete that reading, my lord? That paragraph. Coupled with this is the presence of the elementary disputed facts, especially with regard to the decision to relocate the check at station based on the evaluation at its suitability and the operation thereof departmentally by the respondents. So this is the, my lord, para 11. Lordship is focusing on this. Now, what was the basis of passing the impugned order in this case? Was because of the letter issued by Mr. Kindi. Not because of the traffic.
That has been dealt with.
Not because of the traffic system.
Primarily, it is because of the letter issued by Mr. Kandia, which we would agree with you has no basis.
Right.
But the court has taken an overall view and has considered everything into, taken everything into account. So therefore, this observation has been, issued. Pointed out. My brother is pointing to para 12 also.
Para 12 also. Para 12 made.
That is what has been held by the Reed Court. That this entire, why the Reed Court granted you compensation of 2 lakhs rupees, that whatever is the cost for compensation. It is because the Reed Court came to finding that this entire tender process is abandoned. That is what my lord had basically pointed out paragraph 11. And if you see at paragraph 12 also, it has been specifically provided there. That is why you see, like the question of awarding a cost. Had there been a situation that the contract could have been awarded to you, maybe could have done it. The question of cost would not have come, maybe. At least the compensatory cost. But then here, though the Reed Court found everything in your favor, but then found that this tender process does not survive anymore. But that is what, which way you say address that. That is the only issue to be decided.
No, my lord, may
of course, we would definitely like to know the stand of the district council, what they have to say.
But may I submit?
It would be 1 second.
Yes.
It would be helpful for us if you know what is their stand with regard to this finding. Have you abandoned?
My lord,
This has been abandoned.
but there is no formal order issued to that effect. But the affidavit we filed before the London Single Judge, my lord, that in the change scenario, district council has leased in its own name a different plot of land, which is 5 kilometers away from that
But
place.
what about the tender process which you initiated?
Well, my lord, by implication that is abandoned, my lord. And even the London Single Judge held that continue to run departmentally.
Now, if that be the thing, and if the tender process basically is not surviving, then what relief you expect?
My lord.
You should be happy with the compensation, nothing more.
My lord. I will take the affirmation made by them in the affidavit. My lord. Whether they have abandoned or not.
That is what.
My lord. And admittedly, last occasion also, my friend fairly submitted that NIT was yet to cancel
And
formally.
the clarity which you are running, you will run it by yourself, you will not.
Now we are running ourselves.
So you will be doing it permanently.
Well,
The Kletirsi is not the shifting of that Mukindur. Mukindur has been abandoned, and Kletirsi is the start of a
My lord, we are entitled to.
Has it the shifting? Is it shifting?
My lord, we are entitled to one check gate, my lord, there.
That is okay. So what
So,
do
my
you
lord,
say? What do you say?
what was there in Mukindur, my lord, that is we have taken
And
it
in
to.
such a case, tender process remains. It is not abandoned then. You may have shifted.
Exactly. And Lordship, may
But
I add?
abundant in the sense now district council has taken a decision to run it departmentally because of so many of
Then where
litigations.
is the order you are recalling the tender process, or abandoning it, or cancelling it? Is it before us?
Because you see, the petitioner, rather the appellant by right, you see, is entitled to the fruits of the tender process.
My lord, in my humble submission, if I may give a very simple example, my lord, I own a car, my lord, and I want to sell it. I've issued an advertisement in, for example, Ceylon Times, my lord. Now 3-4 people came from Juwai, from Nongstoin, my lord, and they offered their bid. After 3 months, or before finalizing the tender, I come to conclusion that I don't want to sell it now. Now, what will be the consequences, my lord? At the most, I can be charged with why you issued a tender, then why you caused harassment to these people. But the learned singles is properly taken care of that aspect, my lord. In the changed circumstances, this tender does not exist. At the most, because they came all the way from Nongstoin to see my car, my lord, you compensate them for that. But in my humble submission, it cannot be that can be a direction that you have to sell the car to this particular person.
So long you do not withdraw it, so long it remains, you are public authority. You are not public individual. You are selling your car.
Well,
Where you see like have absolute discretion. When you act as a public authority, let's say it cannot be equated with the act of a private individual, that you do whatever you like, whenever you want.
well, the law of contract to some
Now,
extent.
Here nothing. We have not found anything. Neither it is reflected so far as the judgment of the writ court is concerned. That there is any stand taken by the district council saying that they are withdrawing the tender process or cancelling. Nothing is there.
No, by the decision which we placed before the learned single judge was that we will run it from Kletirsi now, my lord, and we will run it departmentally.
That is
Because
okay,
the petitioner does not have land there, my lord, in
you
Kletirsi.
cannot leave anything on implication. There has to be express decision. You have to express it.
That is a parallel, decision taken without, linking or affecting the other part of the decision as far as the tender process is concerned. What my brother said is correct.
My lord,
So the tender process is still subsisting.
my lord, in my humble submission, tender process may not be said to be submitted as subsisting at this point of time, my lord. My lord, why the decision was taken, my lord? One important aspect of the matter is that earlier Mr. Kindia offered that land, my lord, in Mukundur on the other side. After the litigation, the petitioner, my lord, is offering the same land, which Mr. Kindia, the other party, he offered, my lord. And then in such situation, the other person issued a legal notice saying that this was a land offered by me. How the other bidder also offered.
Anyway, we'll do one thing. We'll finish with Mr. Agresso, sir.
I'll conclude and my friend may give reply. Now that regarding the shifting, Lordship correctly pointed out, NIT is still subsisting because they are vehemently advancing the argument in their own writ petition, which is pending before my lord, that we are running a check gates at Mukundu. And when district council run or Mr. Kende run, my lord, there is no change circumstances. But when I offer, there is change circumstances. They shifted to Kletirsi. Therefore, shifting to Kletirsi, my lord, with my profound respect, it is only a temporary arrangement to avoid me from conferring the contract. They are running it. And district council, single pen say that, okay, department, before you take final decision, departmentally you run it. Even before single bench also they misled that it was departmentally running. It was not. The affidavit is very clear. They invited 2 gentlemen for running in Kletirsi when my case is pending, and they selected Mr. Dang and appointed him. May I just take their pleadings. Lordship has pointed out there was no.
Stand is not a bona fide stand now.
But
Stand which District Council is taken now to run it by themselves.
yes,
It's not a bona fide stand.
Madam.
That is what you want to say.
Madam. Just to avoid me, just to avoid to settle contract with me, they shifted there. And the affirmation made by them in the writ petition, Lordship, just bear with me. The affidavit filed by the council, page number 91, my lord. Page number 91.
Disclosure of any intention that they would want to abandon this.
No, nothing as such. Nothing as such.
Was any statement that they would run it by themselves and not give it to private individual on lease?
Yes.
It is there.
It is there, my lord. And the commission basis, I'll come to that para, my lord. My lordship may keep in mind paragraph 5 of that affidavit. I'll note the, my lord. Then para 6, my lord, that is the admission that after single bench order, they resolved to appoint me. That is what para 6 says. Now para 7, separati, my lord. Separapi, my lord. Page number 95. They say that however it was discovered that the said land now offered by the petitioner is the same land which was earlier offered by the second highest bidder, and such. So this is, they are reflecting this one. That is the same land. But they never take a decision that since you are taking the land of Mr. Kindia, we are abandon the tender. They are not saying that one. Yeah, but even this matter also, learning single bench, touch in the discussion. And
Dr. Majika, see, if you see, come to your affidavit at page 95.
My lord.
Now, at para D, the last line you find, accordingly, the District Council leased a larger plot of land at Tirshi.
My lord.
What do you mean by leased?
District Council took a lease, my lord.
Took a lease.
Took a lease, my lord.
Now, where are those documents and all? That means these are all subsequent decisions. After issuance of tender notice.
After issue of tender notice.
Yes, where are those? Those materials are before this court.
Those have not been annexed.
Any resolution by the executive committee or anything to take land on lease and all with regard to this?
I can place them, my lord. It was not annexed, my lord. But this statement is reiterated, my
It will
lord.
be placed today in the evening hours, second half. It's only 11:50.
Probably I'll get it, my lord.
Sir, so you have to see on what basis that is taken. Let me put it. Okay. I think my brother is correct.
At
You
2
have, to,
o'clock,
you have to prove your bona fide.
my lord, at 2 o'clock I can place that, my lord.
And if there are any indication that it is done, in lieu of the land at Mukundur, See the lease that
I'll
you have
place the
taken.
resolution and the lease agreement, lease deed, whatever document has been there, my lord.
See, what we want to see is that there is a decision by you to abandon the tender process, or to cancel it,
My lord.
and to take a land on lease, fresh land on lease,
Well.
and run it by use.
My lord.
That decision has to be
There, my lord.
there. That should be
Well.
that is what.
Well.
If that be the thing, then appellant may not have a case.
My lord.
They will have to be satisfied with these things.
Well.
But then in such a case, you cannot settle it to anybody else. But then, so far as this matter is concerned,
My lord.
you allotted this Khatirsi also, collection also, to somebody else to on commission basis.
On commission
It's
basis.
only because of their objection, and after this court passed an order,
We will
you
cancel.
discontinued it.
My lord.
So your intention doesn't say. Your conduct and your, you see, action are two different things. Or your submission before the court and your action, otherwise, two different. And that is, we are not getting a clear picture of what your exact stand is.
Well, I'll place whatever resolution is there, my lord. Because, can take it up at 2 o'clock also. I'll try to get
And
it.
if you have taken this thing, you have taken lease from whom and all, can you
Well.
give us all details?
I'll try to get that document also, my lord. The lease document and the resolution or decision that was taken, my lord. These 2 documents I'll try to place.
So we'll take up this matter in the second half.
Second half.
But I beg to mention a listing of a missed case tomorrow, my lord, in a transit bail matter, my lord, wherein your lordships had granted me transit bail for extension of time, my lord, due to certain change of circumstances. I've complied with your lordship's order, went to Calcutta, my lord, to the IO, but IO has asked me to come beyond the period of transit bail. Okay. So just for extension, my lord, just slight modification tomorrow, my lord. Deeply obliged, my lord. Also, my lord, item 10, there's a joint request.
Joint request, my lord.
On pre-made with the parties, list this matter up to 2 weeks.
Deeply obliged.
Please, your lordships. Lordships, I crave your lordship's kind indulgence to move an unlisted motion today, my lord. The urgency is that, my lord, the title suit, which is pending before the lower court, it was listed day before yesterday, and certain, my lord, adversities came up. We asked for some time. Yesterday we prepared the entire civil revision. It's listed again today. So if it's not taken up, my lord, either whether your lordships interfere or not is
Let it come up tomorrow then.
because today, my lord, if the title suit is taken up, we apprehend, my lord, that the petition will become infructuous. So let it, if lordships may kindly consider it, my lord, today. I'm not asking for any stay or anything, my lord.
Then that is.
But the problem is that if it's taken up in the lower court today, it is highly apprehended, my lord, that
Whatever the case may be, Mr. Day, you know very well. See, nothing can be undone. If
there is certain, my lord, issues here, and my lord, because we are asking for a transfer from the particular court, it has been now pending. If your lordships kindly consider it, my lord.
You see, that would involve a detailed hearing and.
Only for the purpose of issuance, lordship may kindly take it up, my lord.
Because you know very well, you see, this is as far as matters not, in the roster of this court. The court will be very, very reluctant. Apart from the fact that the presiding judge of such cases is on leave only for 1 day. Had been 2-3 days or 1 week's leave.
Because grave urgency is there, my lord. If your lordship is pleased to take it up today, my lord, I am humbly requesting, my lord.
But then you have to also, give notice to the other side.
Lordship, yes. We'll do all of that, my lord. It's being filed, it's already filed. I'm praying for today's listing, my lord. Much obliged, lord.
May I please, your lordship? Item numbers, I would like to mention item number 7 from the daily list. Mr. P, and the council, Mr. P. Obin is on sanction leave.
My lord, may this matter come after vacation, my lord.
On pre-made by the petitioner, list this matter after vacation.
Obliged.
I beg to mention item number 9 of the main list.
Just a moment.
Item number 9 of the main list, lordship. I'm praying for small accommodation, lordship.
No objection, my lord.
On pre-made by the petitioner, list this matter up to 2 weeks. Yes, Ms. Stalin.
Lordship, I beg to mention item number 11 as the conducting counsel have some personal difficulty.
You are appearing for?
Petitioner.
On pre-made by the petitioner, list this matter to 2 weeks.
How much obliged, lordship?
Up to 3 weeks. Or after vacation.
Please, lordship.
Thank you.
Lordship, I beg to mention item number 5, the daily list. Lordship, if this matter can be taken up along with the CRP number 36 of 2022, Lordship.
That matter is only.
Matter had come up on the first, Lordship. Lordship had passed order to be listed after 2 weeks. Lordship, as per the case status, I
But
checked.
this would be, decided, I think, after the order is passed in the other case, isn't it?
Lordship. But then, Lordship.
That is what I could understand. The issues here would be mainly dependent on what would be decided there, because that is with regard to maintainability.
Lordship.
So.
Lordship, can be taken up together also.
We'll take it after vacation then.
Lordship.
In any case, once the matter is decided in the other case, I think it will just follow suit.
Lordship. Highly obliged.
Made by the petitioner, list this matter after vacation.
Much obliged.
Please, Your Lordship. I'd like to mention item number 6. Lordship, the matter can come after vacation, Lordship.
Who's for the other side? Right there.
Yes, Your Lordship. Hold it.
On pre-made by petitioner, list this matter to vacation.
Highly obliged.
Yeah, please, Your Lordship. I beg to mention item number 8.
Preparing for?
Should employ this matter may come after vacation.
Pre-made by petitioner, list this matter to vacation.
Lordship, similar prayer for item number 12.
Practically nothing is left. Everyone is in a holiday mood. On pre-made by petitioner, list this matter to vacation.
Highly obliged.
On supplementary cause list, item number 1.
You ready with this matter?
My Lord, this has come as a fixed item, my Lord. But I was requesting some accommodation can be given.
You only have to, I think what we are waiting for is your instructions. Instructions have not come.
It has not come. I'll call them today.
Apparently, from what has been submitted by the respondent, you may have no case. So why would you, see, as I was saying the other day, why would you flog a dead horse?
That's true, my Lord, because it's a CBI. I'll just have a clear instruction from them, my Lord.
Just because it's a CBI doesn't mean that.
I'll just have clear instruction from them, but I'll call them.
That was, I think.
That was quite some time. They've sent me a reply that has no bearing on this, but I'm also not satisfied with the instruction.
Yes, see, the onus is on you. You are to advise them accordingly. You are in a better position to know the law than they. So why would you just drag on with a matter that is
one opportunity?
Last
opportunity.
On premier ready. Leonard DSGI appearing for the petitioner, CBI, seeking accommodation on the ground that specific instructions have yet to be received. Matter is adjourned. We'll have it after vacation then. This is the matter after vacation. We'll do it. List the matter in the first week of February. February, okay with you? Or you're going?
Second week. Second week.
Still cold for first week, my Lord.
No, not cold. I have some.
You can all see. You can always apply, appear online. You may be in Alaska, or you may be in the South Pole. It makes no difference.
I won't be able to carry the. It will be extra baggage, not extra weight.
There's no question of extra weight now. You just need your mobile. Everything is there.
Yes.
Fine. Second week of February.
Daily cost list, item number 1.
May it please your Lordship. Lordship, this is a revision petition against a very small order passed by lower court. Small order, my lord, but an order of some importance because it has affected the entire suit which is pending in the lower court. If Lordship allows, we can start, my lord. Very small issue.
Lordship, before my learned friend starts, I will submit here, Lordship, that in the petition, Lordship, the copy of the annexures which were enclosed along with the plaint has not been annexed. And Lordship, having gone through the plaint as well as the documents, it has been found, Lordship, that your Lordship as an appellate court has passed an decree where the present respondent was the appellant, and in that case, Lordship, his Lordship Justice thank you was a counsel. So that point was also pointed out on the last occasion, and that is how the matter has come before your Lordship now. So I may pray that the matter Lordship may peruse the documents and decide whether Lordship can take up the matter or not. Fast.
I'll respond to that immediately, my lord. Firstly, my lord, will kindly allow me to express my surprise at the submission which has been advanced. My surprise, my lord, arises because of two reasons. One reason, my lord, Lordship will appreciate what exactly are they asking. They're asking my lord to recuse himself from this matter for the reason, according to them, that my lord was a judge in some other case involving some other person, involving some other property, but where he was one of the parties.
Party here.
Yes. So the respondent herein was a party in some other case involving some other person,
but not
involving some other property. I'll explain. Involving some other property, which was decided long back.
But not necessarily the issue in...
No. If I can just give an example, what they're actually asking is, if I can just drop an example with Lordship's permission. Lordship takes up different matters from time to time involving certain parties who are common. For example, I can give an example of NEPCO. Lordship has taken up a matter some time back involving NEPCO. Dispute between NEPCO and a contractor of NEPCO involving a project. That dispute comes before my lord. My lord passes judgment one way or the other. Sometime after that, another dispute comes up between NEPCO and some other contractor, maybe involving the same project or some other project. That dispute also comes before my lord. Will my lord recuse himself simply because of this reason that it involves the same party, NEPCO, and a similar kind of dispute, contractual dispute that that Lordship had taken up earlier? Answer is no, my lord. Answer is no. What they're asking, why they're asking for a recusal is because, if I can explain, their property, the plaintiff's property, for years they've been having disputes with various neighbors. I'm one of the neighbors. Many years back, they had a dispute with some other lady, Elberis Tron. That lady, my lord, if I'm not mistaken, she's on the eastern side of their boundary. So they had a dispute with that lady. That dispute was settled through a settlement compromise deed. Compromise deed was placed before the learned court then. My lord was the presiding officer of that court. Matter was closed. Now they have a dispute with me. I am on the southern side of their boundary. Property dispute again. Different properties, different parties. I am different. I wasn't a party there. Different cause of action, different everything. Simply because my lord had not even adjudicated with respect. My lord was the presiding officer who had taken the compromise deed on board. At that time, they want a recusal from this honorable court. That cannot be, my lord. With respect, I use this word, but this is an absurd submission, my lord. This is an absurd submission. My lord will be disabled from taking up a number of matters in that case. My lord will be away while sitting with the Honorable Chief Justice in the division bench. My lord takes up many arbitration matters. Majority of those matters, my lord, involve two parties, NEPCO and Patel Engineering. Once a matter has been decided by Lordship involving NEPCO and Patel Engineering, involving a contractual dispute, and most of those disputes are regarding one project in Arunachal, 2DL project. Once a petition has been decided, can Lordship not take up the next subsequent petition? Maybe the next subsequent petition makes a reference to the previous judgment, maybe. But that will not disable the Honorable Court. It has not disabled the Honorable Division Bench so far to take up petition after petition involving the same parties, the same project also, what they're asking is that a recusal because of this simple ground. They have managed to get Justice Thank You to recuse himself. Now they're one second. Let me finish. If I can just finish my submission. Now they're asking the same recusal from this honorable court. First reason of why I am surprised. Second reason, my lord will kindly see the approach of the respondents through the years. The suit they filed was in 2008. For the last 16 years, what have they managed to do in the suit? They have managed to examine 3 witnesses. That is all that has happened in the suit for the last 16 years. The last witness which they have, the 4th witness, last 4.5 years they could not call that 4th witness. But they've managed to delay the suit that they have filed. They are attempting the same dilatory tactics since July before this honorable court also, since the time I filed this revision petition. I am not making these submissions in the air, my lord. The order sheets are there of this revision petition. Sometimes the submission is made, senior counsel will argue the matter. Date may be given. Next date submission is made, senior counsel will not argue the matter, my friend will prepare. The next date submission is made, I am not ready, time is required. Next date submission is made, I am not well. Next date no one appears. It has been going on, my lord. It has been going on. Before Justice Thank You also, the same that same dispute regarding Elberis Tron was presented, that you were a conducting counsel in for one of the parties. Justice Thank You in his wisdom said that okay, I will recuse myself. Same attempt is being made before this honorable court, my lord. That will set a bad precedent if Lordship also recuses himself, because the attempt is not to get the matter heard, to disable the matter somehow or the other, and to delay it somehow or the other. Why they are adopting that tactic is very clear, my lord. I am a senior citizen, a widow of about 70 years of age. I am a soft target for them. They are waiting for me to expire, simple as that. They know no one else stays in that property.
Very strong insinuation.
Because no one else stays in that property. No one else stays in the property. My sons are outside, permanently settled out. 2 sons are permanently settled outside. They are waiting for me to expire. During the pendency of this suit itself, in spite of a status quo order, in the absence of my sons, they've gone and cut the boundary walls. In the face of status quo orders, knowing that I am not in a position to really respond to their actions. This dilation, my lord, cannot be allowed anymore, my lord. This is a very, very small issue, what I'm placing before my lord through this revision petition, but it has a deep impact on the suit. I'm attempting to get the suit disposed of through this petition itself. They know that, and that is why they are trying to delay this matter as much as possible, my lord. I would request that
it is not for this court to go into those.
Yes, my lord. On the point of recusal, my lord, the position is very clear. I submit strongly and respectfully, my lord. There is no ground for Lordship to recuse himself. It will set a bad precedent.
Lordship, I will. Firstly, Lordship, he has gone beyond the pleadings and also making personal accusation against me. He had used the word, counsel has used, the word manage. How did I manage before his Lordship? This is an acquisition.
They succeeded.
I have just only succeed. Then this is the proper word he should use.
My English is poor, my lord. I cannot. I'm sorry for that. But the word is succeed. They succeeded.
Mr.
That was a very.
I think you have overstepped.
Used very.
You cannot use.
And Lordship, that was not a conscious use of the word.
You cannot convey such.
Absolutely. There was no intention. There was no intention to. It was an unconscious use of a wrong word, my lord.
In court, everything has to be fair play.
Absolutely. The same fairness, my lord, I would request from them also. Let us hear this matter, my lord. Let us hear. Instead of delaying the matter.
I may submit furthermore, Lordship.
Use of
appreciate that, my lord.
Like I said, employment of emotion in court would not do well.
True, my lord. Maybe in the heat of the submissions, my
Lordship.
An unfortunate word was used. I apologize for
the
that.
court would not sit here, on the basis of sympathy or empathy.
Absolutely.
What I am submitting before your Lordship is upskirt. Those are words has been used. Now, what I am submitting before your Lordship is that I am bringing a document.
Let's
Lordship, yes.
Get to the point.
You're to the point only, Lordship. Now, what I am before your Lordship.
Mr. Budia, firstly, see, if you say personal, this has also become personal.
Lordship,
as much as you are,
those two
you are implying that this court should recuse.
I have pointed out, Lordship.
So if the subject matter,
now further what I am submitting,
if the subject matter has been dealt with by this court directly, involving the issue in hand, then absolutely. But
now it is my
if
it is
not
my
so,
primary duty, Lordship, as a counsel for the respondent also, to apprise the court. Yes, once upon a time this has happened, and the call should come from your Lordship only, Lordship. Call should come from your Lordship, having gone through the documents, that yes, it would be proper or not to decide this matter, to hear it, Lordship. The call should come from your Lordship. It is my solemn duty that I should place before your Lordship that yes, this document has come into, I have come across.
Mr. Wadia, only if this court is called upon to decide on its own judgment.
Absolutely. Lordship.
Then.
Now, further, Lordship, is that suppose the Lordship calls for the record of the case. Now, your Lordship will be examining his own documents also. So, a situation will come up. Your Lordship may just have a look and then and take a call, Lordship, whether to this, and then we will go for the maintainability of this, whether this revision petition is fit to be admitted or not.
What I would request, my lord, is that Lordship
hearing will take place, Lordship, and at that time I will not raise all this issue. Your Lordship may take a call that whether your Lordship will continue to hear this matter. I will. Page number.
What are you trying to produce?
I will try to the annexure 4 of my plaint, which has not been enclosed along with the present revision petition. Revision petition was filed only with the plaint, copy of the plaint without any annexures.
Let's come to the impugn order. What is the subject?
Yes, order. So, impugn order arises on a petition filed under Order 7, Rule 11A. So, my assertion in my petition, which I had filed, was that their plaint is based on no cause of action against me. So, because it is not based on any cause of action under Order 7, Rule 11, it should be dismissed, my lord. My petition was heard. Impugn order was passed saying that no, petition cannot be allowed because according to lower court, there is some cause of action.
But you're saying that it has come to the stage of recording of evidence?
Evidence. But I can file
3 witnesses has been examined.
I can file Order 7, Rule 11 at any stage.
Yeah, that is true.
At any stage. Because frankly, what had happened was in the plaint itself, and I will show this, there was no cause of action. We waited for the evidence to be recorded. That at least show us something in your evidence against us.
Oh, that would,
their evidence was.
See, that would have been explained in your written statement.
Yes, ma'am. So in any event, because the law allows me to file a Order 7 Rule 11 at any stage, I exercise that right and file this even in the midst of the evidence. I filed this. My petition was dismissed. So
that could also be termed as an afterthought.
Yes, ma'am.
That could also be termed as an afterthought.
It could be, but that is not the reason why it was dismissed. According to the trial court, the lower court, my petition was dismissed for the reason, according to lower court, there is cause of action in the plaint. And more importantly, more worryingly, why I was forced to come immediately before this honorable revisional court was, learned trial court has pre-decided the issue. If I can just take lordship to the last page, para 29. Page 52.
Yes.
Page 52, para 29. The encroachment by the defendant in the suit property gives rise for a cause of action to the plaintiff who instituted the suit. Now this, my lord, will kindly appreciate, is an observation of the court, of the same court, who is supposed to pass a decree, either saying that there is encroachment or there is no encroachment. Before passing of the decree, in a miscase, decree has already been granted. Encroachment by the defender. So there is a prejudging of the issue. Trial court has already concluded that I have committed encroachment.
I think of course, we can't say.
Yes,
it could very well, perhaps, we don't know.
It should have been better worded, maybe.
That the allegation of encroachment.
It could have been better worded, but now I am stuck because of this. I have nothing more to argue. My friend also doesn't have to argue anything else in the trial court because there is a finding that I have committed encroachment. So this is possibly the biggest reason. But the larger reason is, according to me, there is cause of action. There is no cause of action in the plaint, and the finding of the trial court that there is cause of action is a incorrect finding, which needs revision and interference.
You are the
defendant.
defendant.
Yes, my lord. So, Lordship will see that there is no commonality in this proceeding and what might or might not have been there in the proceeding that took place years back regarding some other property. So, if Lordship allows, I'll open my case, my lord.
According to Mr. Upadhyay,
yes, my lord.
The property involved.
It's not the same, my lord.
It's not the same.
He is also that one was on the east side of the.
That's why, Lordship, I have make a copy of the plaint. Lordship may have a look at this. Pleadings are all supported by those documents, Lordship.
I think there is no dispute of the bar, my lord, that the previous the previous property was on the
227 is not maintainable.
Was on the eastern side. Was on the eastern side.
That's why, Lordship, it has been listed for admission. First, you should satisfy.
If I can finish my submissions to answer Lordship's question, whether it's the same property, answer is no. It is not the same property. There is no dispute between us that the previous proceeding was regarding a property on the eastern side of respondent's property. Today's proceeding is regarding a property on the southern side of respondent's property. So where is the commonality? Very evidently, it is not the same property. Parties are not the same except respondent. So where is the conflict of interest? I fail to see, my lord.
I think that's correct, Mr. Upadhyay.
Property is same, Lordship. My property has not changed.
I
had a dispute with.
I could understand.
I have a dispute with.
From what you have submitted, I could understand. I can make out a mental picture.
Yes. To the eastern side, I had a dispute, and now with the southern side. And my
eastern side already over and done with.
Those has been decided, and your lordship had passed a compromise decree at that point of time.
Where is the
now lordship?
Where is the bar?
If it is not barred, then lordship it may hear for the admission whether this is a fit case to be admitted or not.
That of course.
Since your lordship has made a taken a call that yes, there is no bar. Now the petitioner must plead his case to the effect that this is admissible.
If I'm allowed to open my case, I'll open my case now.
Is fit to be admitted. Because I am raising the issue of maintainability, and as per High Court rules also, Lordship, any 227 application is filed, it is placed for motion or admission hearing, whether fit for admission or to be admitted or not. So that has to be decided, Lordship.
Now it's at that stage.
Yes.
So
I'll start.
This will take considerable time.
Okay, so we are on the issue of maintainability.
On the ground, because maintainability on the ground, because
227.
He has not raised any ground, my lord. In any event, I'll open my case if he has any objection.
That is for admission hearing. That's why it is for admission hearing. 227 has to he has to satisfy. Why 227? Read with 36A. 36A
if
lies
I'm
before
given a chance to satisfy, I'll satisfy, my lord. So I'll open my. If lordship allows, I'll open it.
36A before Deputy Commissioner or High Court.
Or High Court.
From a decision of the
or High Court, from the language of the rules itself, it's very clear, my lord. In any event, if lordship allows, I'll open. But my lord,
why 227? 227 has only been just added to invoke the jurisdiction of this court, lordship.
First, I have to fire my gun, then he can give his defenses.
But how long will it take you, Mr.?
It'll take me about half an hour at least, my lord.
I will also take some more time.
Because we are already at lunchtime. At 2 o'clock, I believe there is some.
Then we will not be able to take up this matter today.
May fix it any date.
Lordship, there is.
Of course, urgency is always there. You see, Yes.
That is true, my lord. There is urgency.
Urgency is there, Lordship.
If
the case is filed by me, I am in this 2008 matter,
16
and he
years.
is filing in 2023 the maintainability application, which has been rejected by the London trial court.
See, I have not even glanced through
that there is no cause of action.
I have not even glanced through the papers. But
So
if,
there is.
if
I am what submitting is this. There is no urgency.
If what have been submitted is true, that you are trying to delay the matter, then
no, Lordship. Lordship may fix any date.
The law will not come to you.
I have not.
My lord, I will request.
Previously, Lordship.
I will request, my lord. I will request, my lord, if convenient, my lord. If not today, tomorrow or Monday, my lord. Monday would be a good day.
Monday.
When he opened up his case, Lordship, he has raised several questions.
Monday
is
on me.
Because I think we have a DB matter.
I see. I see. Then tomorrow or Tuesday, my lord, if that is convenient.
We'll take it up on Tuesday. Then you
Tuesday
come.
Tuesday is a holiday, my lord. I'm sorry.
I thought you were willing to come.
We can have a holiday bench.
I'm always happy when.
I'll be more than happy, my lord. 18 years I've been struggling with this case, my lord. Wednesday then, if that is convenient, my lord. 13th.
If it could be, Lordship, on 14th.
Fine. We'll take it up on Wednesday. 13th.
Highly pleased. Highly pleased.
On pre-made by parties, this is matter on 13th.
The issue of Lordship's recusal need not be. Very well. Very well. Obliged.
Unless you file a petition in that regard, then they have to.
I hope he does not.
That is pointed out by me, Lordship. When the call has come from your Lordship that yes, Lordship will take up the matter, then it ends up there.
Yes, Mr. General would.
Yes, ma'am.
Tomorrow, if the matter goes to some other forum, what will be pleaded?
The only thing is this, Mr. Padia.
Yes, Lordship.
If you can, produce those whatever relevant papers are there, and let me go through those papers. The plain or the order passed by me or
by way of affidavit.
Not by way of affidavit. Not by way of affidavit.
I have a copy of the plaint, my lord. Over the weekend, maybe if Lordship is convenient, Lordship can see it and satisfy Lordship.
No, not the plain. More pertinently, it would be the order that.
Lordship's order is here in the plaint itself.
Order is there.
Order is the previous order.
Let me just have a look.
Yes, Lordship.
Then I will take a call.
Yes, Lordship. Yes, Lordship. It will be better, Lordship, because otherwise, if Lordship decide the matters tomorrow, the parties will go for before the appellate court, Supreme Court, or SLP or anything. Then what will be the pleadings?
Absolutely. If Lordship is not convinced,
what will be the ground?
If Lordship is not convinced in Lordship's mind that Lordship should take up the matter, no one should insist.
No, I am not insisting, Lordship. Yes. I have just pointed out that this has happened.
In all these things,
this is a fact.
In all these things, you see, one thing that is
we cannot.
One thing that would rise. As a query, would be the issue of bias.
This was pointed out before the other bench. The other bench recuses it. That is different. The same thing I have done. I discharge my duty, Lordship. Sincerely, I discharge my duty of showing the right thing that this has come into my notice, and the rest is your Lordship to take a decision.
A conducting counsel taking up a matter between the same parties. Some other matter, as a judge, maybe there is some possibility, I will not say too much possibility, of bias. But this case, where my lord was a judge in some other case involving some other property, but just involving him as one of the parties.
Now I have to clear my conscience.
Yes, absolutely.
So we'll take it up on 13.
Obliged. Highly obliged.
Item number 3.
May it please, Your Honor, Your Lordship. We are on behalf of respondent number 3. So we'll be filing a small objection to the condemnation filed by the petitioner. So we are seeking for a week's time.
Oh, you have just entered appearance.
We entered on the last day.
Should have done it by now.
So.
How many days delay?
300 days, sir. Delayed by 300 days, sir.
You should have a very good reason for it.
It is not
because
it is
it's
not the
very
length of
difficult.
delay, Your Lordship. It is the explanation whether this
Exactly,
explanation is
that's what I said.
satisfactory or not. Your
That's what I said. You should have a very good reason for it.
So
Let
they
them file
are
their
all
response.
senior citizens, then
Those things will not. We'll have to look at what the law says.
not having any source of income, then they cannot come also, sir. Many of them, they cannot walk. So
We
this has to be allowed, sir. Because
Lordship, 1 week's time
it's
we'll file
very
our
difficult
objection.
for them.
We understand. We
But
understand.
how much time, sir?
We'll have to look at.
How
we'll have
long
to-
they will wait? You are from Mekupet.
Okay, we'll take it up on 14 then.
Okay.
1 week's time. Counsel for the respondent 3 has submitted that he may be allowed to file a response to the application for condonation of delay filed by the review petitioners. Accordingly, and the prayer is allowed, let the petition be filed within the next date fixed with advance copy to the petitioner and the other respondents involved. As prayed for, this is matter on 14th.
Highly obliged.
Item number 4.
Lordship, in this matter, we've taken steps for respondent 1 to 4 and number 6. Still waiting report.
Any confirmation?
There's no confirmation. Lordship. We'll have to file the factum of service as well. Because we've done by registered AD.
No, any AD card. This office note says AD card has not been received.
Yes, Lordship, we're still waiting for it.
So we wait.
We'll wait. The correction also has been done, Your Honor, as per the last order. There was some typographical errors.
And the counsel for the petitioner has submitted that pursuant to this court's order dated 22/11/2023, the typographical error which has been discovered in this petition has been duly corrected. As far as the confirmation of these receipt of notice issued upon the respondent's number, respondent 2,
So 1 to 4 and 6.
1, 2, 4 and 6, the counsel has submitted that confirmation has not been received so far and has prayed that the same may be awaited. Are you filing your counsel?
So far as this is concerned, Your Lordship, R5 is concerned, Your Lordship, there was an FIR filed by them, Your Lordship, that has been duly inquired, Lordship. Then we have what the police has done is they have forwarded it to the executive magistrate under section 107 on 22nd 11. Then it is pending before the executive magistrate and
What remains?
So the letter still remains, Your Lordship, where we've been restrained from entering the whole village. That's the whole issue.
If you have been restrained, then what's the point of issuing a proceeding under 107?
Lordship, there was an FIR, Your Lordship. FIR has been inquired, Your Lordship.
Yes, it has been inquired.
Now
the IO,
because
now the IO has proposed
apprehending that there may be a breach of peace
right?
and tranquility, Your Lordship. That is why we have initiated a 107 proceeding.
What about the allegation that the petitioner has been?
No, that is not by the state authorities, Lordship. That is by the village headman, by the village authority, Lordship.
No, in that respect, I think the FIR was filed.
No, FIR was not filed in that line, Your Lordship.
Or not?
It was filed, Your Lordship, in that line itself, for the demand, extortion, and as well as restraining us from entering the village.
But the FIR remains that has been stated, Your Lordship. That letter has been stated, issued by the village authority. That has been stated.
The only thing is, you have to ensure, that security is given to the petitioner.
No, Your Lordship. 1-0 proceeding, Your Lordship, is sufficient, Your Lordship.
because the executive magistrate there will bind both the parties, Your Lordship.
But can you ensure that that she is allowed to
Enter the
to
village.
enter the suit? I mean the
Lordship,
dispute
in case any,
course.
in case any, they should approach the
Yeah,
police.
because the fact remains that you are not a resident of that.
Yes,
Yes.
she hasn't.
So
Though
only
she's
as
saving
and
a
when
lot.
it's required, you will go there.
Yes.
So in that event, as Mr. Shulai has said, prior to your proceeding to the land, you inform the police,
That's not true.
and then if security is required to be given, it will be given to you. Mr. Andy Shulai, Leonard AG has appeared on behalf of the respondent 5 and has submitted that as far as the FIR in question is concerned, the police has taken necessary steps and has also
Initiated 107 proceedings CRPC, Your Lordship.
initiated
10 CRPC
proceeding under
proceeding,
section 107
and has
CRPC,
been forwarded to the executive magistrate.
which the same of which has been forwarded to the concerned executive magistrate. This being the case, to address the apprehension of the petitioner, this court would direct that as and when the petitioner visit the land in question, she may inform the authorities or the police in advance, who will take necessary steps to ensure that the provision of section 107 is duly complied with.
Lordship, that is for the magistrate, Lordship. Magistrate, you will have to issue notice to both the parties. Then a bond will have to be.
No, the magistrate will do it, but in
Only
case
to ensure safe passage to the area.
because there is prima facie, there is a prohibition by the concerned village durbar. So that has to be addressed.
For that, Your Lordship, that is for that I will not support or defend that kind of action, Your
That's
Lordship.
what we have to ensure that no bodily harm is done. As prayed for, this is matter to vacation.
Vacation, yes.
Matter to vacation.
Apply.
Oblige, Your Lord.
Supplementary 1, item number 1.
Also, I'll try to make it as quick as possible.
What is this?
Lordship, this is a civil revision, my lord, for transfer of the suit under section 25 of CPC. So, Lordship,
What does section 25 says?
Lordship may kindly take section 25 of CPC, my lord. Section 24. Sorry.
Mr. Dunn, I think like I said,
We have tried to serve, but the problem is that notice has to be issued, otherwise they are not also willing to accept the copy. So if I may only satisfy lordships, if I have if it's admitted that notice will be issued, we will take it up on tomorrow also for consideration.
any interim prayer?
Interim, if I may just show your lordship what has actually
please,
happened. Lordship may kindly have section 24 CPC first. These are the, my lord, sections which we are invoking. Section 24, my lord, has it?
Yes, please.
Lordship, section 24, 1B, lordship. If I may read from the beginning. On the application, this is my lord, general power of transfer and withdrawal. On the application of any of the parties and after notice of the parties and after hearing such of them as desired to be heard, or of its own motion without such notice, the High Court or the District Court may at any stage, B, my lord, withdraw any suit, appeal or other proceeding pending in any court subordinate to it, and I skip my lord's Roman 1
Roman 2, my lord, transfer the same for trial or disposal to any court subordinate to it and competent to try and dispose of the same. My lord, and if I may also take your lordship's attention to subclause 2, lordship, where any suit or proceeding has been transferred or withdrawn under subsection 1, the court which is thereafter to try or dispose of such suit or proceeding may, subject to the special direction in the case of an order of transfer, either retry it or proceed from the point at which it was transferred or withdrawn. And another very important subsection, my lord, is subsection 5. A suit or proceeding may be transferred under this section from a court which has no jurisdiction to try it.
Lastly,
lordship. Now, my lord, I also crave your lordship's indulgence to refer to, my lord, the Administrator of Justice Rules 1937, Rule 1B, lordship. Otherwise, we have quoted it in the.
Where is it?
Lordship, may kindly have my petition at page 19, my lord.
Yes.
Lordship, paragraph G, lordship will find at the top. It is also relevant to mention that under rules for the Administrator of Justice so-and-so 1937, Rule 1B of Chapter 1 provides that, in quotation, my lord, the High Court may, for any reason which it considers proper, transfer any original case, whether civil or criminal, at any stage, when it is pending or under trial before any court, to any other court competent to try it. So what I am trying to say, my lord, is on the conjoint readings of Section 24 and Rule 1B, it is an absolute discretion conferred upon the High Court, my lord, to transfer any suit which is pending in any court subordinate to it to any other court which is subordinate to it, either as a de novo or from the same point it has been transferred. And it can also be done if the court which is now seized of the matter does not have jurisdiction under subsection 5. Now here, my lord,
Tell me, what is your grievance now?
What has happened, my lord, is that a title suit was filed very recently on 22nd of November. And it was filed, my lord, in connection with this All Saints Cathedral, which is located here in IGP Point, my lord. There was a dispute between the presbyter in charge and the committee and so on. But those are the merits of the plaint, my lord. The plaint was filed, my lord. If lordship will kindly see the plaint, which I have enclosed as Annexure 1, my lord, at page 26.
Yes.
Lordship will see, this is the entire plaint, my lord. Plaintiff and 2 defendants and 1 pro forma defendant. Lordship, what is here crucial is the heading of the court, the name of the court which has been addressed to. In the court of the Assistant to Deputy Commissioner Judicial at Shillong, which would, my lord, by way of implication, it would mean that it is under the ED rules.
Yes.
And not under the CPC normally. However, my lord, in the entire plaint, there is no such specific invocation of the Administrative Justice rules or the provisions of the CPC. It is, my lord, so you will see the cause title at this next page at 27. Suit for declaration of right, title and interest along with a permanent injunction.
I think the jurisdiction should be, that of Munsif.
Lordship, yes. So I'll show what is the confusion that has happened. Lordship, thereafter, my lord, the suit was filed on 22nd of November. It was listed, my lord, for consideration of the injunction application, and the learned trial court below, my lord, White order dated 24th of November, which lordship will find at page 253, my lord. Annexure 3 at page 253, my lord. 253. Marked with the blue pen, Annexure 3, page 253, my lord. Lordship will see in the court of is the same court, my lord.
Yes.
Assistant to Deputy Commissioner, so and so, present. Shri Don Misil is the presiding officer, my lord. Miss case number so and so. Lordship, this is the order of 24th of 11, 2 days after the suit was filed. And Lordship will see at paragraph 6 of this order, at this early stage, limited relief is granted on ex parte basis, such that the petitioner is not deprived of his shelter and is not restrained from discharging his duties, which are continuous and continuing. Therefore, till the next date of hearing, the petitioner is not to be evicted from the premises occupied by him by OP number 1 or 2 or any person acting through or under them except by due process of law. And 2, opposite parties number 1 and 2 are restrained from interfering with the petitioner's discharge of his duties as presbyter in charge except in the manner as permitted by the Constitution. Another prayer was made, my lord, with regard to the salary, but that was not entertained at the ex parte stage. Now this order of 24th has been extended, my lord, till date. Now, my lord, what happened when the case was listed day before yesterday before the learned trial court? An objection was raised by the opposite parties, my lord, that the cause title of the suit is addressed to the assistant to the deputy commissioner, but this area which the suit premises are located in falls under the European ward or the normal area, so it should have been Munsif. Now, my lord, why we are before this honorable court, my lord, is that I have two limbs of submission, lordship. One is, my lordship is already aware that if I quote the wrong provision of law in a suit or any other application, as long as the court who is seized of the matter has the jurisdiction and the power to try it, maybe in another section law, then, my lord, that is not fatal to my suit or my application. First, my lord, here what has happened is, apart from the name of the court to the assistant to the deputy commissioner, there is no other infirmity or otherwise any such impediment which would oust the jurisdiction of the honorable court below. And, my lord, the court, upon finding a prima facie case on behalf of the in favor of the plaintiff, has passed a injunction order which has been extended till date. So the court has also gone through the material on record, and I am not, my lord, trying to say that if the court has taken up the matter, it is deemed to have jurisdiction. They have raised the objection, and we have, my lord, come before this application saying that, my lord, that if now there are two possibilities, lordship. If the court takes up the matter, it appears, my lord, that the prima facie they don't have the jurisdiction. It should have been addressed to the Munsif. But here what is very crucial, my lord, is that it is the same judge, the same presiding officer, who is also acting as the Munsif under the CPC as well as the assistant to deputy commissioner under the administrative justice rules.
Oh, that's immaterial,
lordship. And moreover, once the court has seized of the matter, now if I have to file a fresh suit only by changing the cause title of the court, then, my lord,
but you could have you filed an application, for transfer.
This is the application for transfer, my lord, before the High Court, because under the administrative justice rules it will not lie before the district court. That is why under 1B I had pointed out at the very outset.
So instead of going to the the trial court for that, you have come before this court.
Yes, under 1B of the administrative justice rules, because under 1B, my lord, only the High Court has the absolute discretionary power, for any reason it deems proper, to transfer any suit pending before a civil court to any other suit.
I don't think there's anything wrong with it.
So, I mean, what is our apprehension, my lord, is that lordship has seen the interim order passed. There are two imminent threats against the plaintiff, my lord. One is that he may be asked to vacate his premises, his shelter, and secondly, he is being restrained from doing his day-to-day activities in the church. And only on that aspect, the limited relief has been.
See, Mr. Deb, the point is this:
not sure.
As long as this order is still, in place.
In place.
It has not yet been dislodged.
No.
By an order passed by Supreme Court.
Absolutely.
Nor by by the same court.
Absolutely.
So it remains.
It remains.
Where is the apprehension that this order would not be applicable?
No, my lord.
If it comes to that.
If what we are apprehending, my lord, is that if the learned court, the case is fixed today, my lord. If the learned court decides that because I have written the wrong name of the court in my plaint, that it will return my plaint or otherwise dismiss it, what will in effect happen, my lord, is that the injunction order will go.
Sir.
And again, I have to file the same exercise will be taken up by the same presiding officer who has in any case passed this order. And no such prejudice will be caused because this is an ex parte injunction, my lord. It is not finally decided. Both the parties will be heard on merits, and eventually an order will be passed.
It can come under 39 Rule 2.
Order 39 Rule 2, my lord. So in that case, my lord, if I have to take the exercise of withdrawing my plaint, only changing the name of the court from assistant to deputy commissioner to Munsif, It will go before the same presiding officer with the same prayer.
That would, you see, that would require administrative exercise.
Administrative under Rule 10A of the CPC, that is powers with the lower court, my lord.
It is not simply by
Absolutely.
crossing of a pen
Absolutely.
and overwriting. No, that will not.
Absolutely, there is provisions for that, my lord. But why we are coming here under Section 24 is because Lordship has seen under Clause 5 of Section 24, this Honorable Court has the power to transfer a suit which is filed in the wrong court to another court which is competent to try it. And on that regard, my lord, I humbly submit that if I have to withdraw my suit and file it in another court again, then severe prejudice will be caused to me, my lord. Even it may be taken up on the same date, but that vacation of the injunction order would seriously cause severe prejudice to me.
When is the next date fixed? You said
Today,
yesterday?
my lord. Today.
Oh, today.
Today. So I am praying, my lord, at this stage, notice may be issued. Both the parties may be heard, my lord. And till then, the status quo may be maintained in the suit.
What, Mr. Estep, letter counsel for the petitioner, who has submitted that this application is filed before this court under the provision of
page 9.
Rule.
Page 9.
Where's the,
Page 9.
Page?
Page 9 is the cause title. Lordship will have
No,
the section.
no, I'm the provision of the rule.
Lordship,
You were referring just now to
Lordship, yes. I was referring to page 9.
19, isn't it?
Yes, 19, my lord. 19, that is Rule 1B, my lord. Page 19, paragraph G.
Rule, kunung to go? In the filing for this court, seeking exercise of powers of this court under the provision of Rule 1B, B capital B, of the rule for administration of justice and police in Acacia and Giant Hills, 1937, analogous to Section 24 of the CPC, Code of Civil Procedure. The submission of the Learned Counsel is that a title suit was preferred before the court of the Assistant to the Deputy Commissioner at Shillong, who has taken cognizance of the same in the of the same entitled suit number 27 under bracket D of 2023 between the parties herein. That order was passed in a miscase.
In the order application under Order 39, my lord.
What is the miscase number?
Lordship, miscase number 1170.
Just
Lordship, page 253, my lord.
253. The letter trial court. In an application there's already an objection.
Lordship, yes, they have raised the objection on day before yesterday, saying that it is in the wrong court.
Oh. Then that becomes a problem.
No, my lord, if I may humbly submit, if the court doesn't have jurisdiction, there is no question of dismissing a suit. What the court will do
That's
is
not the
they
point.
will return.
The point is now they are conscious of the fact that the matters, that suit has been filed in the
Yes,
wrong
yes,
court,
yes.
and for
And-
which they have also applied before the court for. Now you are to defend
Lordship, yes.
your case.
But in any case, even after filing of their objection, the learned court has extended the interim order.
Okay.
It has not interfered with the interim order.
Move to go. In the trial court on an application filed by the petitioner herein under order
39 Rule 1 and 2.
39 Rule 1 Rule 1 and 2 1 and 2 or 1
My application is there at page 228, 1 and 2, my lord. It's an application
2,
under Order
CPC
39, Rule 1 and 2.
has passed an order dated 24/11/2023 in Miss Case number 117 under bracket D of 2023. Inter alia, restraining the opposite party of the respondents herein to interfere with the petitioner's function, isn't it?
Lordship, yes.
Petitioner's
Not
function.
to evict and not to interfere with my discharge as the duties of as the presbyter in charge.
Petitioner's function as the presbyter in charge of the Shillong diocese.
It will be Shillong pastorate, my lord.
Or
They have not
Shillong,
mentioned
Shillong pastorate.
pastorate.
However, apprehending that then I think this court has to take note of the fact that an application has been filed.
Yes, yes. That is why we've enclosed it. We are not suppressing anything.
Where is that application? This is
Lordship, the next annexure, my lord, annexure 4. Lordship will see this was filed on 5th December.
the Learned Counsel has further submitted that the respondents herein has also preferred an application under section 21 section 21 of the CPC, objecting to the jurisdiction of the trial court to take up the matter between the parties, such application being registered as Miss Case number 127 under bracket D of 2023. Under such circumstances, the petitioner has impressed upon this court that in the event an order is passed ex parte as far as the Miss Case number 127 D of 2023 is concerned, the petitioner would be deprived primarily of the advantage of the injunction order already passed in his favor. In such an eventuality, the petitioner has accordingly approached this court with this incident application the prayer that the title suit may be transferred to court of competent jurisdiction. It is also submitted that notice may be allowed to be issued on the respondent, and in the meantime an order of status quo may be passed to restrain the parties or the trial court for that matter from disturbing the position of the parties as it is on date. That would I'll correct that. On consideration of the pyramid, the petition is hereby allowed. The prayer of the direct counsel of the petitioner is allowed inasmuch as the petitioner is directed to take steps for issue of notice upon the respondents. In the meantime, as prayed for, pending. In the meantime, as prayed for, status quo is hereby directed to be maintained as far as the proceedings before the trial court, proceeding of the case between the parties before the trial court is concerned. What else?
Not sure for that much. Because essentially it's a
the notice issued is returnable within 2 weeks. This is the matter thereafter.
much obliged, my lord. It was a silly mistake, I would humbly submit. Should have been addressed to the Ponsev, otherwise there was no problem.
Yes, of course.
But then since they have raised the objection, so I also, my lord.
Because the courts rather would be more interested in going to the merits of the matter and to adjudicate the matter accordingly.
Shillong has this peculiar, my lord, situation where 3 courts are there. There's the district council court, the deputy commissioners, and as well as the district judge. Perhaps some, but we are grateful.
Ini arbajin kan ujung arbajin rupiah gitu.
Second call from daily cost list, item number 2.
But the first one is
dark background.
But because I got it from mobile, my lord. So.
To adjust my eyesight to this.
Supply the copy to the other side.
Yes. But the first one is lease agreement, and the second one, my lord, the lordship kindly sees at page 4, my lord. Resolution number 9, my lord.
No, this is not in dispute. We have taken that decision
to shift the check.
Now we are only on the issue of whether the tender process has been abandoned or is still continuing.
It appears because what happened, my lord, the learned single judge in the previous round of litigation order, the judgment was passed on.
Exactly, we have, I think that was in paragraph 12, when the learned single judge has observed that the project was abandoned. But there is no substantial evidence to that.
My lord, what I am submitting, my lord, the first round, the judgment was passed on 26/9/2022, my lord. In the earlier round of it.
Your executive committee decision is 29/11/2022.
My lord.
And then this judgment of the single bench is 11/9/2023. And then you see that is.
Yes, that is reflected in the order, in the judgment.
Nothing. There is no reflection of this aspect. Neither in your affidavit also.
Yes, my lord. Affidavit I'll point out, my lord.
When this tender process was initiated and when it was, if you have done it, then after 29/11, what are the resolution which was challenged, Mr. Chandreswar, before the London single bench? What are those dates?
First petition, my lord.
First petition decision is after 29/11/2022, or?
The first petition, my lord, we have challenged. My lord, just point out.
See,
page number.
See, here the court order says that re-examination of the matter was done on 26/10/2022. That means after this they have taken the decision to change it.
My lord, the copy supplied by my friend now is on 29/11/2022.
Yes.
Now, Lordship, can I see page number 88 of my writ petition of the single bench direction. Page 88.
Yes, 2610.
My lord, 2610. So this 2610 is based on resolution, my lord, 18 October.
So we can
18 October. Right. October. Worship got it. On that basis, I was offered. I was asked to provide a suitable land. And thereafter, my lord, it appears page number 100. EC decision. Page number 100. EC decision is 14 March 2023.
Even page 100 also,
100 also.
it does not say anything about shifting.
Nothing.
But then this is this resolution which Dr. Mochika has produced just now is before this.
Well, 29/11.
Yes.
2022.
My lord, what has happened, my lord? When the first round of petition was filed, my lord, the interim order was passed by this honorable court, saying that the district council will run it departmentally, my lord, and there was interim order, my lord. So pursuant to that, during the pendency of the single benches matter, first round of litigation, we continued to run it departmentally, my lord, and that matter was disposed of on 26/9/2022, my lord. 26/9/2022, the first round of litigation, my lord. And there was a direction, the final direction that it will continue to be run by the district council, my lord.
Until a fresh settlement is made.
Until the matter as per the direction is, a decision is taken, my lord. Then we took a decision, then they came again before this honorable court, my lord. During the pendency of the second round of writ petition also, the district council was running it departmentally. Now, district council was running it departmentally at Mukundur only, right from beginning, my lord, since the time of first writ petition. Then they're facing difficulties. So, independent of matter pending before this honorable court, my lord, the district council faced the difficulty and they leased a new plot of land and shifted the gate there in the month of November. And they ran it departmentally for some time, my lord. Then they appointed an agent for that, and that was ultimately recalled, my lord.
Now, say supposing that is the thing, then why this decision to shift it is not reflected in a resolution which has been taken on 14th 2023. Come to page 100 of the
yes, sir.
memo copy.
It's not reflected, my lord.
Why it is not reflected? Nowhere it is there.
But the decision-making process is, I cannot say, my lord. It is there. Because on first occasion they're denied on different ground, my lord. Second occasion they denied on different ground, my lord. Page 100 is denial on the ground that there is a legal notice.
Yes.
In first round, denial was on the ground that there is no lay-by.
But then the thing is that if you say that there is a decision, implied decision, to abandon the tender process in view of the shifting.
My lord, specific in what I understand, my lord.
To support the finding recorded in the impugned. So impugned order has been based upon that thing. That since it is a decision of shifting it.
Well, that is the decision, my lord. This is only decision.
And that finding is not challenged by you. You are not challenging the finding.
This finding that
of the trial court. Sorry.
Of the learned single judge, my lord.
The judgment which is impugned here.
My lord.
Judgment what is impugned here,
My lord.
if we understand it correctly,
My lord.
here the compensatory cost was
My lord.
allowed to the
My lord.
writ petitioner
My lord.
because the writ court found that this check date hasn't shifted.
Yes, my lord.
And the tender was abandoned.
Tender.
That is come to the finding.
My lord, in our affidavit, what you have said, I'll just.
My lord, also in the morning paragraph
My lord.
11 was what, and then subsequently found in paragraph 12 also.
My lord, page 95, my affidavit, my lord, in this writ petition, my lord. Lords have already seen that, but again,
D.
Para D, my lord.
No, if you say it, then it is not reflected in page 100. Whatever you say in affidavit, it is not reflected in your resolution.
The shifting to clear test is, that's what we have said in the affidavit, my lord. Because of traffic issues.
Your executive committee decision is 14/3/2023. There is no indication.
In that is not reflected, my lord.
Now that is what was under challenge before the writ court. Yes.
Yes.
So to support your action, you file this affidavit. And in this affidavit, you have raised this contention, which basically is a kind of improvement upon your thing. It is not been reflected there. So this reason which has been mentioned in your affidavit in opposition cannot be added to this.
To the impugned order.
To the impugned order.
To the impugned order. But in this resolution, this was reflected, my lord. The resolution I placed before lordship now.
That is before. That is why surprising. If there was a decision, okay, then there should not have been that this thing. This should have been reflected in. See, this could have been reflected here.
My lord, idea what it appears to me, my lord, is that because I have submitted since the time of first writ petition was filed, or even before that, my lord, the department was running the gate from Mukindur, my lord. Now, state government order came that it should not be on the highway. Then single judge, we wanted to give to private respondent the other writ petition. That was stayed, and so we had to, this one we could directly run it departmentally. We continue to run it at the Mukindur, my lord. During the pendency of second writ petition also, we continue to run it the Mukindur only. In between first writ petition and second writ petition, that was sometime in the month of November, they faced that there's a lot of traffic issues. And they took a decision to shift that departmental running to that place, my lord.
That you are telling us now. But what is the reflection of that in your?
In the order, my
lord. What is the decision that to shift it? Rather, if you see the last part of page 100, it says that the executive committee hereby entrusts the CM and EM in charge taxation to work out the manner and mode of appointment of an agent of the council who shall operate check station on behalf of the council.
So initially, because what happened, my lord, what they told me, there's manpower shortage, my lord, to run it departmentally. Facing difficulty. My lord, both the decisions are not going in hand, my lord.
That is the problem.
My lord.
There is a problem.
What
that is the precise reason we wanted to see this.
Traffic issue is going parallelly, and the writ appellant is offering a different land that is going parallelly. In a decision, they should have reflected both the aspects. That is not been reflected.
What is this decision dated 26/10/2022? There was a decision to, of 26/10/2022. I think this was impugned in your petition.
Well, 26 then, this is the letter issued to me.
Yes.
By the district council of the single bench direction that you offer suitable land.
Yes.
And we will settle the contract to me.
Okay.
This is in 26.
So now this letter has been cancelled.
Yes. And in response to that, page number 89, I have given my reply. It is the 24/11. 24/11. And if we go by sequence, after I offer this one, it seems that the documents produced by my friend, meeting was held on 29/11/2022.
After this letter of 24th.
Yeah, after my letter. But nothing reflect about my land also. And page number, my lord, 90A of my memo of appeal.
Yes.
The one we challenge.
Yes.
This one, as well as the executive committee, my lord, page number 100, my lordship Padaji has seen. In both the impugned, this letter resolution dated or minor dated 29/11/2018, nothing reflects.
That is what is very
Nothing reflects. It's afterthought. And surprisingly, the list deeds furnished to us now, dated 18 November 2022. To go to clergy. That means even the lease was obtained by district council from private landowner before district executive committee adopted the resolution to go that side. See the date. Lease is 18 November, and EC meeting is 29/11.
No, 29/11 has only confirmed that the land has been leased. He informed that the council had leased suitable land.
Normally, executive committee need to take a policy decision
whether to lease or not.
Yes, to abandon the Mukundur, and they take a decision. Then thereafter, my lord, they go for leasing other place, and subsequently they find Mr. A or Mr. B. Then they can execute the lease deeds, and adopt a resolution and start the business. That is normal process. But here, the process is nothing as such. In IT remain the same. Policy decision at Mukutu remain the same. They go for releasing a private person on 18 November. Thereafter, they come back to EC, and EC appear to sit on 29/11. And when they pass an impugned order, nothing as such reflected at all. This is, my lord, with due respect, it's all afterthought. I become the problem with the district council. That is the only reason. And Lordship has pointed out that it's all supplementary. Affidavit has nothing. Did not spell out. Forthrightly, even if they did not reflect in the impugned order, so the law says that validity of the impugned order will be tested on the ground available on the face of the impugned order. Even if it is not there, for assuming, they could have spelled out clearly in the affidavit that this is the situation, these are the things. That time we could have challenged, if required. Things would be different.
Yes.
They never disclose it. And this event is completely different now.
Well, only one important aspect, my lord. The land in Mukundur department was running, my lord. Then Rudolph Kindia offered in the NIT same land, my lord. And then subsequently The appellant herein offered the same land, my lord.
Why you are running? See, first that checkpoint was running at Mukundur departmentally.
My lord.
The same land was offered by that Kindia.
Kindia also, my lord. My lord, that land belonged to Kindia only. Then subsequently, when this Honorable Court interfered with Kindia's appointment and we wrote to them to offer an alternative land, she offered the same land, my lord. And in the meantime, with our experience, when we ran the check gate, it was very clear that that is not feasible anymore because we increased traffic. There are so many issues, my lord. So we took a decision that we'll shift it to literacy. Though there is no, it appears that there is no specific order recalling the tender process. Maybe that is because the matter was, there were certain directions to be complied with issued by this Honorable Court.
That be the thing. Did you inform the petitioner of the decision to shift the location?
I don't think, my lord, that I have to check that court.
According to Mr. Sangriso, he has not, petitioner has not, rather the appellant has not received any communication.
The communication that has been given to her is that her land, alternative land offered by her is not suitable.
Yes. And that, see that 26th and 2022 letter was, recalled or cancelled.
Yes, only that, only cancellation.
My lord, one important aspect, my lord, if you lordship kindly sees this, my lord, what is the import of this letter, my lord? Page 88, my lord. My friend is referring to this, my lord, again and again. But the second para I'll read. Therefore, you are requested to arrange a suitable land with lay-by that can be used for the purpose of operation of check stations so as not to obstruct, disturb the movement of traffic along National Highway. Kindly note that you have to comply with the requirement of providing land and lay-by for operation of check station within a period of 2 months from the date of issue of this letter for consideration of the Executive Committee as deemed proper. It was not a final offer, my lord. She has to offer land. We will check that whether that is feasible or not. So in my humble submission, by this letter, no right was accrued in our favor. My lord, today the situation is like, my lord, to set up a check gate at Mukundur, my lord, whether in the name of Rudolf India or to the petitioner, my lord, that will create a situation that the check gate also itself will be, my lord,
invalid to me.
No, there will be government directions and so many things, my lord, and traffic jam and other things, my lord. My lord, in that view of the matter, if your lordship permits us, because I talked to them, my lord, we can issue a fresh tender for literacy, my lord. She can also participate, everybody can participate.
Normally that is what should have been done, but then see what you have pointed out just. On page 88, what you have said, it is dated 26th October 2022.
My lord.
Time given was 2 months.
My lord.
So at least you are supposed to wait for 2 months. Now it seems like petitioner responded to it by page 89.
My lord.
That is within 2 months.
My lord.
24th.
My lord. We are not denying that, my lord.
But
my lord, that is admitted.
Your lease agreement is before that.
Before that, my lord.
How can it
my lord, why it was?
If you have given time till that much, why should you execute this lease agreement?
No, my lord. These are two things. The matter pending before this honorable court, first round of litigation, second round of litigation, tender matter, my lord. This is one, and they are running departmentally, my lord. That is where they made a mistake, my lord.
This issue is not connected with all those factors. You see, the offer to the writ petitioner or direction to the writ petitioner to look for an alternative location is made on 26th October 2022.
Yes, my lord.
This is in pursuant to the earlier order passed by the single judge.
Yes, my lord.
Time given was 2 months.
Yes, my lord.
That means 26 October, 26 November, 26 December.
My
Isn't it?
My lord.
Now what happened before that? Petitioner response.
My lord.
By next page, 24th November, he makes his offer.
My lord.
But then it transpired that before that you have executed this lease agreement, apparently to defeat the interest of the petitioner. The offer which you are making, this you yourself violating.
My lord, in my humble submission, not necessarily, my lord. My lord, that was leased by us. Till the time we have to run it departmentally, my lord.
You see, you have done everything without communicating. What inference we can draw?
My lord, will kindly see the lease is only for a period of 2 years.
3 years. Whatever it is.
2 years, I think. Only with the idea that till the time under the directions of this honorable court we have to run it departmentally, my lord, we will run it there.
I could never say you should run it. You see, like this is not given in a specific period. It is only for the purpose to facilitate the settlement process, nothing else.
But direction was there, my lord.
Now,
If we want to run it, we have to run it
pursuant to that,
departmentally, my lord. Yes.
You have communicated with the writ petitioner,
Yes, ma'am.
being the highest bidder, made some offer. He responded to your compliance to your offer.
Offer
But
the
then
land.
before you take a conscious decision on that, you jump on other land. Why?
My lord, that's why I'm trying to submit, my lord.
It means your decision to shift was taken before you decide the suitability of the land.
No,
offered
no,
with it.
no, my lord.
That is what the inference.
No, my lord, that inference I'll try to, my lord, we took the land, my lord, only for the period till such time that we have to run it
But
departmentally,
then
my
you have
lord.
taken a decision on 18th.
Yes, my lord.
Then, see, 18th means before the respondent could respond.
Yes, yes, my lord.
That there lies the entire problem.
My lord, but that was only for the purpose till such time by under the interim order or till we settle with anybody, we have to run.
Was it
Well,
not-
of course,
was it
some
not-
inference, my lord.
Was it not sufficient to prove your intention of shifting? The entering into lease agreement on 18th. Of course, this court don't know whether you are getting the points which.
I understand, my lord. Some inference, my lord, I can see, my lord, going through the papers also.
You with
that you
your
should have,
standing for
ideally,
so
they
long,
should, ideally,
you
they
will
should have
understand
waited.
what the court is trying to point out.
Well, ideally, they should have waited
Offer
for 2
was
months.
made on
my lord.
26th October.
Well.
With 2 months time, given 2 month time. Response was given on 25th November
Well.
2022.
Well.
Before the expiry of that time.
Before that, they released the land.
But then what happened? It seems you made an offer, but then you did not wait for his response. Before that, you take a decision to shift. Then what remains? That is the only conclusion we can draw from here.
That inference, my lord.
That is good enough.
But my what I understand and what is my instruction, my lord, that they took on lease that land only for the purpose that till the time they have to run it departmentally, they'll run it there,
We
my lord.
understand that.
And
We
if you have to
understand that.
settle it, if you like the land offered by her,
But then we
check it will
understand
come
that.
back to Mukundur, my lord.
But we understand that. But then at the same time, you have not done what is expected of you pursuant to the order passed by the writ court. Though apparently it seemed like you have done, but then see, abruptly you take a decision. Even the process you start in pursuant to the earlier order of the writ court, that also do not allow it to be completed. Before that, you take a decision to shift and start of your own. So this is a total arbitrariness in my part.
Well, decision-making process, the learned single judge is held, my lord. The decision-making process is flawed. There is serious flaws. But the problem remains, my lord. The ground reality remains that from the same land, my lord, where we are running the check gate for many months, my lord, right from 2022 till now, my lord, we are facing a lot of difficulty because of traffic, my lord.
Now we give it to him.
If your lordship permits, we will issue a fresh tender, my lord.
Let us give it to him. Why fresh tender? You have not.
If your lordship directs, you have to give it. But in my humble submission,
That is what is entitled to it. If it is a shifting of the same check, then why not? It will come under the same tender process.
but the system is different. Here, the land is leased by the district council. Your lordship permit us to issue a fresh tender, we will do that.
District council has hired a land, and then they will never treat us. Okay.
See, the legal issue involved here is with regard to the tender process as such, whether, as has been queried by this court from time to time, whether it is still subsisting or not. On that, you see, on that point, if you can prove that it has been abandoned, cancelled, then the appellant has got no stand. If not, then if it is continuation, then it has to stop somewhere.
My lord, but that is all that is available in the record, my lord. That one decision and lease agreement is signed, and the rest of the resolution on record, my lord. But by implication is that the check gate at Mukundur has, at least the place Mukundur is abandoned, my lord. That is not possible now.
No, but Dr. Musika said is that from the whatever is there, it is implied that as far as Mukundur is concerned, that place has been abandoned. Mukundur is.
It is not possible to run the check gate from there, my lord.
And what the appellant has.
If Lordship directs that Cleartirsi is now the only possible venue, my lord, or maybe some other venue if they can offer. But Mukundur is out. It appears that is out of question, my lord. Looking at the ground realities, Cleartirsi, on that your Lordship has passed an order. In my humble submission, my lord, the learned single judge found the decision making was flawed, my lord. I admit to that extent. The decision making process was flawed, and to that extent, the learned single judge imposed cost on us. Alternatively, your Lordship permits will issue a fresh tender, my lord, for Cleartirsi on different terms and conditions, because the land belongs to us now, my lord. That can be a way out, my lord, in the given scenario. If she participates, she succeeds.
That's the only recourse. That only recourse, because see, practically, as far as you are concerned, your offer is only for Mukundur.
And same land, my lord. Same land.
Left, right doesn't matter now. The fact remains that through the various resolution passed, that area, you're talking about the process, the area has been abandoned. So if that is the case, then the whole purpose of the NIT, of the tender process, is gone.
My lord, my submission regarding this is these minutes had produced before the very single bench. Decision would have been arrived in a different way. It is apparent, my lord, the record speaks for itself. Now, admittedly, NIT subsistence. If the decision taken by the district council to shift from Kuntur to Cleartirsi is in accordance with law, I have no case. I have no case. But if Lordship found that no, the decision-making process from shifting to Mukuntur to Cleartirsi is arbitrary, discriminatory, clearly targeting the writ petitioners, then Lordship, my humble submission is, we pray that Lordship would ensure that the NIT need to reach to its fruition. It has to reach its objective. And I was also informed that in the Mukundur area, even district council is running forest department check gates. They run. Same Mukundur area.
But whatever, see, Mr. Sangisu, whatever is there, you see, in the mind of this court, as well as of the learned single judge, is the fact that because of the government, advisory, I don't know whether it's an advisory or a directive with regard to the traffic issue, that has prompted the district council to shift from Mukundur to KHC. Otherwise, if the land has been found suitable, you would have been given the final contract.
My lord, I bow down. After learned single bench directed them to relook the matter, and they offer me this 26, and I offer my reply on 24th, and they come to conclusion that yes, Mukundur is no longer feasible. Adopt a decision and shift it there. Then that is different case. My ground would be different. But they didn't say that one.
Yes. Now you go back to the only reason they gave was the legal notice.
That is why. These are the traffic is always a supplementary. Always a supplementary to the impugned order to ensure that I cannot get the contract. That is the only logical conclusion. And my friend advised me that if Lordship direct them to.
What is the date of that legal notice?
Legal notice.
What is it dated? I'll just read it.
Legal notice may just read, my lord.
Your legal notice or the legal notice of India?
Yes.
That the latest one, basic one, which they have taken the decision to cancel the offer.
Well, Mr. Kindia legal notice, maybe. But not, Lordship, kindly see page 100, second paragraph.
2811.
2811.
2811.
Yes. By this time, they have already executed the list with the person in liturgy.
That is what is surprising part. Before legal notice came into existence, they take a decision to shift. And they cancel the entire offer made to you on the basis of the legal notice.
Right.
So shifting is not the consideration.
Shifting is not it.
This is something which they are saying now.
Exactly.
Anything else?
Last, my second prayer for alternative, it is no longer, my lord, I will not press this alternative prayer. The ground lordship records
You want
for
dismissal
itself.
of this appeal?
My lord, and Mr. Dang appointment also nullified by my friend
Yeah,
himself.
that is the thing.
My lord, so that ground is no longer. Only the main ground, main prayer, lordship kindly consider.
You will reply on merits?
Well, I think that is the only thing.
My lord, we can submit the gist of the point tomorrow if lordship permits, along with the decision.
Gist of the points.
Yeah, that please. You can do the same thing.
My lord.
You can do the same thing. List of the
bullet
gist of
points.
your
Yeah.
submission
Along
and
with
the authorities. Will do it tomorrow or when?
I
Only
guess
2 days time.
Monday, it may come on Monday, we will submit, both of us will submit, along with the citations.
You go to court, master.
Okay. We'll list this matter again because I don't believe in reserving judgment and then wait. Because sometimes it may come, may not come.
Yes.
So, this is on 13. Heard learned counsel for the parties. Hearing is concluded. On prayer made by the parties to submit gist of the submission advanced before this court in written form. This matter is now posted for the next date.
Yes.
This is the same on 13th.
I do.
Deep.